Welcome to Widener University Commonwealth Law School. I'm Christian Johnson, the Dean of the Law School, and I'm thrilled to have all of you here for our 10th annual John Gedid Lecture Series, named after the founder of our Law and Government Institute, Emeritus Professor John Gedid. It's been a very good year for the Law and Government Institute here at Widener. We were recently named one of our top 20 programs in the nation for law and government by Jurist Magazine. Thank you. We had Eugene De Pasquale, the Auditor General of Pennsylvania, was here a couple of weeks ago to talk about the state of Pennsylvania. We continue a very active CLE partnership with the Pennsylvania State Bar and also with the Dauphin County Bar. The Honorable Mary H. Levitt, our jurist in residence, provided a terrific program on Pennsylvania appellate judging the other day. We've also provided a very important forum for the candidates that were running for Supreme Court justices to express their different views, and many, many other activities. We very much appreciate you joining this evening, and I'd now like to turn time over to Professor Jill Family, who's the director of our Law and Government Institute.
Thank you very much, Dean Johnson, and to all of the Widener Law Commonwealth faculty, alumni, and students for their support of the Law and Government Institute. I'd also like to say a quick special thanks to Sandy Grafe and Brian Fernbaugh for all of their help in planning all of these events, and also to my Law and Government student fellows, Patrick Parsons and Jocelyn Schultz, who are both here this afternoon. I want to thank them for all of their help. This lecture series honors John Gedid, one of the founders of our law school, and as Dean Johnson said, the founder of our Law and Government Institute. And these lectures celebrate the work of outstanding young legal scholars and John Gedid's enthusiasm and support for our law school and for developing legal scholars. The Law and Government Institute is all about public service. The Institute is dedicated to the study of government law, including the role of lawyers in making and implementing laws. At Widener Law Commonwealth, students may earn a certificate in government law in addition to a JD. Government law is fused into our curriculum at Widener Law Commonwealth. And as Dean Johnson mentioned, we're very proud of the fact that we were recognized as a top school for public service by Pre-Law magazine. The Institute's mission is founded on the idea that government works, that government is a positive force in our society. And at Widener Law Commonwealth, we train lawyers to be a part of that positive force. And if you're interested in learning more about the Institute or our upcoming events, the Institute is on Twitter, and you can follow us at WidenerLG. That's at WidenerLG. We are so glad that John and his wife, Carol, are here with us this afternoon. And as we usually do, we want to take a moment before the lecture begins to recognize them and all of their contributions and to thank them for helping to make Widener Law Commonwealth the great law school that it is today. So if you could please join me in a round of applause for John and Carol. And we have a small sweet gift. And also every year we give to John, we take the flyer from the program and we have our speaker sign it. And so we add it. This is the 10th one. And this one from Professor Fairfield says, "Many thanks for building this wonderful community." So I'll give this to John and to Carol. After this lecture, please join us for a reception in the gallery, which if you head out this door of the room and head left, you'll find your way to the gallery. And now it is my pleasure to introduce you to our speaker. Professor Joshua Fairfield is an internationally recognized law and technology scholar specializing in digital property, electronic contract, big data privacy, and virtual communities. Professor Fairfield's current research focuses on big data privacy models and the next generation of legal applications for cryptocurrencies. Professor Fairfield has published numerous articles in many well-respected law journals. Also, he has written about consumer protection issues related to technology for major news publications like the New York Times and Forbes. He is an elected member of the American Law Institute. And today, we're very lucky because Professor Fairfield is going to talk to us about some new research which involves the issues surrounding whether law is keeping pace with technology. Please join me in welcoming to Widener Law Commonwealth, Professor Joshua Fairfield.
Well, thank you so much for being here. Thank you, John and Carol, for creating this wonderful community in this series. And thanks to Jill for bringing me here. And to Juliet, who's sitting right behind John and Carol, who has inspired my work for pretty much a decade now on virtual worlds, virtual property, and the next generation of cryptocurrencies. So what I'm going to talk about today is a story that I hear a lot in the news. And it seems to me there are two stories. So let me begin with the one that you all knew was going to be coming, which is the iPhone controversy. You can't go to a tech talk now without getting hit in the head with this. So the narrative of the iPhone controversy is this, that law has not kept up with technology. That's James Comey's claim. And that the internet is going dark because we do not have law that permits law enforcement to do its job. Fair enough. However, there's a second set of discussions that go on about law. And those discussions go a little bit like this. They go, not again. So in the 1990s, we had people say, the internet is something new, and people are now free of government. No government cannot actually get to people in order to enforce the law. We're free. No, we figured out how to enforce against people, bad guys across the internet. But then we saw it again in sort of the early 2000s. Napster said, oh, well, there's this new technology that lets us transfer information from one of us to the other of us. Law is now irrelevant. Technology has made law irrelevant. Right? No. Napster got shut down, and although we have Spotify on our phones, things have evolved. They haven't evolved so as to be unrecognizable. People buy MP3s now instead of buying CDs, but the world's a recognizable place. And yesterday, I just went to another conference. This is on the cryptocurrency Bitcoin, and guess what I heard? Money now has been freed from the banks, and law is irrelevant. And law will never be able to regulate this space. No. No, we've already got regulation moving into this space as fast as it can. So there's two stories, one of which gets a lot of play in the press, and is sort of a bad rep for lawyers, which is, law can't possibly keep up with technology. The internet's going dark. And then there's this other narrative that law is already waiting outside the door in a dark alley for technology to come out. And law bangs it over the head and goes through its pockets for loose change. That law is already there before technology can even manage to put things together. How in the world can that be? What in the world can we make of this second story, this story that law is somehow anticipating technological change, that law is ahead of technological change? And that's what I want to talk to you about today. I want to talk to you about a vision of law that says this is what law is. That law is the system for accommodating change. Think about it. You go to a court and you ask the court to decide a question. Now, look, either you haven't done your research and so you don't know what the court's going to say, and nobody in this room would ever do that, or you're going to the court because the question's got something convincibly new about it. Now, a lot of times, the reason that something's convincibly new is because there's new technology. I'll go even further. I'll go even further and say a lot of law. We don't think about it as technology law, but a lot of law, maybe all of common law, is technology law. Everybody, or many of the folks here have been to law school, right? Okay, so contracts class. We're going to just do this. Contracts class, right? Now, anybody here have a really, sort of paper chase traditional contracts class? What's the case I'm going to reference here? Hawkins versus McGee, absolutely, right? Weird contract case. Bizarre. The hairy hand case. So just to remind some folks, in the hairy hand case, what happened was there was a contract, and the idea was that the doctor was going to there was going to do a skin graft to the person's hand. And that there was a contractual agreement that said that the doctor guaranteed the results. I also wonder if you could have your tech person maybe get this online. Or I can do that too. So the doctor guaranteed the results of the medical procedure. Now you got to ask yourself, why? Have you ever gone to the doctor and signed a contract where the doctor guarantees you a specific outcome? Says it's going to happen this way. Ever happened? Anyone ever? What is this doing in a contracts book? Why in the world did they write a contract about it? Because it was a new technology. Because they were doing something for, not the first time, but close to it. Nobody knew how this was going to work out. And so in order to encourage the person to go through, the subject to go through with the operation, they had the process of contracting. And so we get this rule, like the rule of expectation damages, which is you get what you expect out of a contract, but it's cloaked against this idea of evolving technology, and that's the reason for the case. Okay, another really famous case, because I'm going to give you guys all post-traumatic stress disorder back in law school. That's what we do. We're law professors, right? Hadley versus Baxendale. Yeah, remember this one? This is the mill shaft. Yeah, see, somebody got back row going, the crankshaft case, right? So the crankshaft case said essentially that you're going to take your damages as you find them, and that you can't retain information about your damages to the other party, right? So in this case, the problem was that the railroad failed to ship a crankshaft to the plaintiff. The plaintiff's mill broke down and was out of operation for quite some time. And the argument was, look, you needed to tell the shipper. If you had this problem, if the railway were to screw up and not get you your crankshaft, and then your mill is going to rack up huge damages, you need to tell the shipper that, so that the shipper can do things like charge you a mountain of money to ship it. Why? Because they're going to be self-insuring. Or tell you to go get insurance of some kind. But what's the case really about? Or at least partially about? You know where I'm going with this. It's about the railroads, right? It's about whether or not you can make the carrier liable for industrialized damages. See, that crankshaft was not just like breaking a wagon tongue on a wagon. That crankshaft was critical productive capital, right? You needed it, and you racked up lots of damages if those weren't there, and you were relying on an industrial, mechanized process to get that crankshaft to you, okay? So what we're looking at is a typical legal rule, but the legal rule comes out of this context of industrialization. It comes out of this context of completely reworking the transportation grid. And so we see this, by the way, everywhere. Property law. What's the first case? What does the fox say, right? Pearson versus Post, it's the fox. What possible value can the law of capture, right? That was the black letter law. The black letter law was the law of capture. Well, what in the world could the law of capture have to do with high technology? Certainly I can't tell you any stories about how the fox was some sort of robo-fox or, right? What am I going to do with this? Well, my kid brother, who works for Google, he builds the self-driving cars, and he got an offer to go work for an asteroid mining company. Now, they haven't quite gotten it off the ground yet, which is why he's still working for Google. But what's the law with respect to an asteroid if you're mining it? Yeah, I mean, see, this is like my students, right? If you whisper it, I'm going to look. Yeah, it's the person who gets it first. I can hear it. It's the person who gets it first. It's the law of capture. We use the same law for, of course, oil extraction. Any system in which we've got unappropriated resources waiting around, we use the law of capture. We have to use completely different property rules once something's been fully utilized, and we're now trying to portion out, say, for example, farmland. So we use the law of capture when we're homesteading. We mark off, it was actually called hatchet rights, tomahawk rights throughout a lot of this country at one time. The woodsmen would come out and they would mark with a tomahawk, and the tomahawk rights were a source of big fight, actually, as to who would own it, the title owners or the tomahawk rights owners. Be that as it may, these rules stand the test of time. They are the kind of law that is waiting for technology. I'll give you a series of cases that have been before the Supreme Court recently, and we can see how they work out. So United States versus Jones. United States versus Jones, the Supreme Court asked whether or not it's all right to put a GPS tracker on somebody's car, even though the car is likely to go into private spaces. Court said, 1, if somebody's got a reasonable expectation of privacy, no, you can't track them. 2, Scalia and a majority of the court, including Justice Sonia Sotomayor, who made the deciding vote in the middle, said, there's something else. You can't come onto somebody's property and cross that bright line and sort of make somebody's property spy on them. Really? Because it does. They used the oldest laws, the laws of trespass, to solve the newest cases. Cases of cell phone searches, right? Riley versus California, the case in which the Supreme Court decided, Justice Roberts wrote, if you want to search a cell phone incident to arrest, you need to get a warrant. Well, why? The police are entitled, if you have a cigarette pack, this is what the case has said, if you had a cigarette package on your person and it's full of heroin, the police can search that when they arrest you. Why can't they search this? And the court said, well, there's something different about this. It's got too much of your life built up in it. It's got papers and effects, things we used to protect under the Constitution. And besides, it's your property in a different way than the package of cigarettes. Again, using the oldest rules to determine the newest cases. Okay. So I think that a lot of law is technology law. I think a lot of the common law responds to changing markets and changing technologies. I think that what law is a system for adapting human behavior to technological change. And so when we say things like the law is being left behind by changing technology, that doesn't make sense to me. What that means is that some rules have gone away. But doesn't that mean that those rules are obsolete now, and aren't we back to the old story of going dark? No, not really. Maybe we need to change how we see how law emerges, how it dies, and how it stays alive. So how does law emerge? We might say law emerges when legislators write laws. And that's the source of a lot of the discussion about obsolete laws, right? So Oren Kerr was here. He spoke at one of these previous lectures, and he said it's time for a new Electronic Communications Privacy Act. And boy, is he right. When we wrote this thing 30-odd years ago, it seemed reasonable to say that email that you left on your Gmail account, right, that you didn't download to your local computer, well, that must have meant you didn't want it. You were throwing it away. And just like the police can go through your garbage, the police could go through the emails that you were throwing away by leaving them in the hand of the email provider. All right, that rule is nonsense on stilts for a cloud computing environment in which we all leave all the stuff that is the most important to us on the cloud. That statute is sort of famous for being out of date, out of touch. It needs to be replaced. That's one way of looking at law. That's not the way that I'd like us to look at law. I'd like us to look at law in the way that Bob Cover looks at it, a great thinker whose article Nomos and Narrative is one of my very favorite pieces of legal scholarship. He says, you know, lawyers don't generate law. Legislators don't generate law. People in relationships generate law. The law arises in rooms like this from people talking. You generate a rule. You come up with something. You come up with a deal, some way of getting along. And maybe you and I have a different way of doing it than other people do. And maybe someday those rules come into conflict, and maybe someday we have to go in front of a court. But the court doesn't make up the rules that get brought before it. The parties do. The court doesn't create law, it kills law, right? Think about it. Two litigants are coming, and one litigant says, no, what we need here is Rule A. And the other one says, no, what we need here is Rule B, all right? And the court says, we're going to select A. Well, the court didn't invent A. The court just killed B, right? The court killed off the law. But that's not the, so common law courts aren't the origin of law either, just like legislatures aren't the origin of law. Rather, human relationships, organizing human behavior. We come up with rules. If you've got kids, you know how this works, right? There are fierce negotiations over the latest stuffed animal. My daughters are into these TY stuffed animals. Every time we get a new one, there are intense negotiations about who can have it, when, for how long, and with what freshness, right? I just got it, so I get it for blank, blank, blank. Okay, I'll let you have it for this, but then I get the stuffed squid. Yes, they gave me a stuffed squid for my birthday. So then I get to play with Daddy's stuffed squid for a while. So they negotiate these things out. They create rules. Those rules then may be adjudicated by harassed parents or judges or what have you. But the adjudicator isn't the source of the rule. Okay, so that's how law is born. Law is born in rooms like this. Now, how does law die? Well, law can die in a couple of ways. One, judges can kill it off by selecting one rule and therefore saying all the other rules are now gone. Two, though, I'd like to take a turn from biology to philosophy to talk about how laws die. So the great American contribution to philosophy in the world was American pragmatism. And the idea was, if it works, good. If an idea changes how you act, then maybe that idea actually has strength, has valence. If you believe something and it doesn't change how you act, well, then you might as well not believe it. That's the philosophy of pragmatism. I'm going to apply that to law and say, if law doesn't change how humans act, then it might as well not exist, right? If law doesn't impact us in any way, if it doesn't change what we do, then it really isn't a law at all. And I think that that's how laws die. There are lots of laws still on the books, mostly in the States, about technologies that no longer exist. We all know the ones. The famous one, I guess, would be the ones where you're supposed to go in front of your horseless carriage with a lantern so that you don't frighten all of the other horses. But there are lots of other ones, actually. My German friends find this hilarious. And they gave me, when they found out I was a lawyer, they gave me a series of books that I cannot make this up. Germans think this is the funniest thing in the world because, you know, legal jokes, right? They're Germans. They think this is good. They collect all of the statutes that are still in the books that don't have any meaning to anyone at all. And it becomes this tome. The title of the first tome is Nachtduschen ist streng verboten, which is showering naked is strictly forbidden. There are lots of others, state laws that just don't make any sense whatsoever anymore. Why? Because they've been pulled out of context. They apply to different technologies. They don't mean anything to any humans anymore. So when we say law can't keep up with technology, my answer is, yeah, that's not law. those things that can't keep up, those rules that can't anticipate how technology changes, those lawyers that can't anticipate how technology changes, yeah, they're just not relevant. So that is how law is born. It's born in rooms, not from courts, not from legislatures. It's how law dies. It's not a natural death. It fades as the rule ceases to have anything to do with us, or as judges kill it off. Now we get to the good part. How can law, in the midterm, between when it's born and when it dies, how does it stay alive? How does it stay ahead of technology? I think there are certain things that we can identify in our law classes, things that you were taught here, taught elsewhere, that help you understand what makes a case or a story or a legal rule good. Nobody ever told me this when I went to the University of Chicago Law School, and I wish they had. Right? There are multiple reasons for cases to be in case books. So reason one, it's the law. Yeah, that's almost none of the cases. Reason two, it used to be the law but isn't anymore in some sort of really interesting way. It's an anti-precedent, right? Those are the ones that drive my students nuts. Why is it in the book if it's not the law anymore? And I explained to them that my favorite class in law school was a class called Defunct Legal Doctrines with Judge Easterbrook. No, why is it in that? Because we don't care what, I tell my students, I often don't care what the law is right now. I care how it's changing. The change is what matters. And so the reason that those old cases are in the books, the anti-precedents like Lochner, Korematsu, right? The reason that those cases are in the book is so that we can see how the law changes. That's, by the way, the title of this talk. Took me long enough to get here. Delta. Delta is a measure of change. It's a mathematical measure of change. And what I'm going to say is that what matters about law is not what the law is. That law is not a system for describing rules. That law is a system for guiding legal change. I was on the train last night wishing for it to get here faster and faster. And I was thinking, I was a little bit worried about the fact that Amtrak had a wreck recently. And I suddenly thought of the following analogy, that sometimes we think law is supposed to slow technology down, right? Keep the train from going too fast. No, not really. Law is supposed to keep it on the rails. It's supposed to let technology go faster and faster and faster and faster and faster, but without letting things come to a break, come to a place where things come off the rails. So how does law do that? What are the good cases in our textbooks about? What are the good ones, the ones that get passed from lawyer to lawyer at conferences about? What do they do? Well, they do a couple things that we can identify. First thing they do is that they are humble, that they deal with one situation at a time, one technology at a time. Why not? Why wouldn't we want to make cases big, broad, expansive? Well, the reason that we make them humble about one case at a time, about one issue at a time, is related to a best practice of software coding. What you want is to build your system out of Legos. You want one block to fit on another block to fit on another block to fit on another block. And out of those blocks, you can build anything that you want, right? What you need is for the blocks to fit together neatly. Now you can carve a whole beautiful sculpture at once out of one block of marble. But if you do that, you can't replace any one part of it. If the sculpture gets old or stained or dull, you can't yank one part of it off, the hand off, you can't hack the hand off the marble sculpture and just plug another one on. It doesn't work. With a Lego system, it's modular. You can take one section off, replace another one in. We see this in industrial design all the time. My water heater, my fuel pump is usually what goes. Some components in some cars can be taken out, put to the side, get another one, plug it in. That's what humble decision-making does in case law. It keeps the case modular. It keeps it nicely, tightly contained so we can build legal structures out. Okay, what else? Common law is experimental. So it tries again and again and again and again and again, and it never gets it right the first time. It is iterative, which is different from experimental. Iterative means that we're going to take each version and build on it, kind of like software code. So we say, I get it. So the rule for Fourth Amendment search and seizures is you can't just walk into somebody's home. And then we iterate that. No, the Fourth Amendment protects people, not places. You remember that line? So we're going to say you can't come into this phone booth either, even though it's not a home. Yeah, but what happens if you're doing the equivalent of coming into somebody's home, but they're not really there? Is that okay? And what happens if you're trespassing on their property? Right, so we add each layer one at a time to get a better aggregated rule. So good law, common law is humble, it is experimental, it is iterative. It repeats and it improves over time. And I think that that is what makes the common law one very strong path for these rules that bubble up in conversations, in communities, among technology fiends. These rules bubble up very, very quickly. Those of you, so it's already a little bit passé, but those of you may remember the Google Glass phenomenon, right? The glasses that people could wear and record everything around them. I won't tell you what people who wore those got called. But I will tell you that if you walked into many West Coast bars wearing one, you got strong pushback. People immediately recognized that the technology was invading their privacy. They didn't care whether they had legal rules backing them up. They said, look out, you can't wear those. Movie theaters said, no, you can't wear those for a completely separate set of reasons. The legal rules were developed almost immediately in response to the technology. And that kind of law, I think, can maintain us for the long term. Okay, so to recap where we've been. Law is a system for helping us manage social change. It's not a system for recording where we've already been. It's a system for guiding us where we're going to go. It doesn't do a great job encapsulating in legal statutes what we already know. That doesn't seem to be the part of law that keeps ahead of technological change. But rather recognizing in industry self-regulation or in discussions between technologists or in court decisions, the rules that are constantly bubbling up about the use of technology. That is the law that stays one step ahead of technology. Finally, we understand that technology can make rules obsolete, but what it doesn't mean is that there won't be any rules. It just means that some rules got made obsolete, the others are already bubbling up. All right, so in my final remarks here, in the final 10 minutes we've got before I'll open this up for you for questions, I'd like to talk about what we can do to protect the parts of law that stay ahead of technology. And here we've got some work to do. There's an interesting phenomenon. My e-commerce textbooks, there was one that came out in 2007, and then one that came out in 2009, and then the next one didn't come out, and didn't come out, and didn't come out, and didn't come out. And people keep saying to me, oh, you work in electronic commerce, you work in cyber law, oh wow, boy, there must be new developments in the law all the time. I mean, it's really hard to stay on top of that. I go, no, not really, nobody's updated the case book in 6 years. What happened? Something very specific happened. And I don't want to get into the politics of this, but I do want to put my finger on a very specific thing that happened. At that period in time, what happened was that online contracts began to include the following provision. Thou shalt not go to court. You have to go in front of a private arbitrator, which is a perfectly reasonable way of settling a dispute. My mom required me actually to be trained as a mediator before she would let me go to law school. It's a perfectly reasonable way of resolving a dispute. But companies wanted these arbitration agreements, frankly, to avoid the threat of bet the industry class actions, right? That's what they wanted. They're happy to make the customer whole for the most part. What they don't want is to get hit with a bet the industry lawsuit. So this weird confluence of events where the consumer has a sort of a reasonable voice in the arbitration proceeding, although the New York Times just did an expose end of last year that says that A lot of these arbitrations don't end well for individual consumers. But that's not my point today. And the companies had a legitimate, I think, interest in avoiding sort of gambling their company every time they get sued in class actions. That seems like a legitimate interest. But there was a side effect that nobody noticed. Technology cases stopped going to court. We stopped getting new cases. Nobody updates my e-commerce textbooks because law is dying at the edges. Law's like a coral reef, right? We look at its big bulk of the coral reef for the most part. We don't realize that most of the structure of a coral reef is dead. It's only the edges that are living, that are still growing out. And what happened when consumers stopped being able to go to court was that courts stopped being able to render decisions based on precedent. We stopped being able to work out new rules. Now, some of it's still there. A lot of law is still alive. Industry self-regulation is still alive. Best practices, very much still alive. The FTC has sort of tried to scramble to cover the gaps, and in certain areas like privacy has developed a very weird common law-like process for settling its suits against companies so as to create a sort of precedent. Although, by the way, what's the binding precedent of a settlement of an FTC action? It's very strange how this is developing, but it's developing because that living edge of the law, that tip of the candle flame got snuffed out. That's an example of the kind of thing we're going to have to think hard about. I don't have a dog in the fight about class actions. I think I worked defense side when I was in private practice. I think sometimes that can be a very hard discussion to have with a client. Right? Whether to proceed with something that you think has no merit, but good grief, the numbers are so big, you really want to bet your company on this? I've got a lot of sympathy. I've also got a lot of sympathy for consumers who say, wait a minute, I can't get in front of a judge, and by the way, if a company is just careful to ding everybody for just a little bit of money so that no one would ever bother to hire an attorney, well then without class actions, we can't actually bring the lawsuit. I'm very sympathetic to that set of problems, and I don't have an answer for it. What I am going to say, though, is that the resolution of those questions has quite by mistake turned the tap of cases, turned the tap of decisions off. Okay, what's another thing we're going to need to do in order to protect the parts of the law that stay ahead of technology? Well, another thing we're going to have to do is what I'll call the law of large numbers. So if you think about cases, right? Hawkins versus McGee. Hadley versus Baxendale, Pearson versus Post. These rules are always an A versus B, a 1 versus 2, an individual versus an individual, or a group versus a group. We can pack these people up. But what we don't do very well with this common law method is making rules of general applicability. We leave that to the political process. We have for years. But unfortunately, the truce between the political process and the judicial process has broken down a little bit because technology has forced it. So, may the police search or seize my property? Well, that's a perfectly clear question we can answer by reference to the Fourth Amendment and its jurisprudence. Okay. If a police officer wants to stop my car, wants to search my car, and take a look inside, there are rules for this. We have rules for individuals, but we don't have rules for what if the police officer wants to do the same thing to everybody all the time, right? So there's one search on one person one time, but now we've got technology that permits us to search everything on everybody all the time. I'm not going to say, again, politically speaking, I've got no dog in this fight. I don't know whether it's a good thing or a bad thing that we're able to do this. But I will say we have nothing approaching a Fourth Amendment that can handle the question of if one police officer can bring one dog up to one car, can police officers use chemical sniffers that do the same thing to every car as it goes through a commuter tunnel? I don't know. Neither do the courts. Because again, law hasn't yet been able to engage in this big switch between adjudicating rights between individuals and adjudicating rights between large, very large group size numbers. In fact, the courts in this area. It's kind of awesome. One of my colleagues, Margaret Hugh, has written a fantastic article, which is not out yet, but she may forgive me for citing, in which she says, actually, courts discussing questions of mass surveillance, of saying not just can you search me at this time using this technique, but can you search everyone all the time using this technique, that they actually are so at sea for law in this area that they have turned to literature. They're actually citing George Orwell's 1984. They don't have anywhere else to go, right? They're going to science fiction to find thinking that has grappled with this law of large numbers. Okay? One last one before I'll take your questions. I think the last thing that we're going to have to do for law to stay well ahead of technology is deal with the fact that a lot of our social contract, our basic constitutional order, isn't what we thought it was. What we thought were civil rights and civil liberties turn out to be transaction costs. So we see this, for example, with Justice Alito's quite accurate depiction of the problems of surveillance, saying, look, you could have surveilled Mr. Jones on the road if you'd put, remember the tiny constable? If you'd put a tiny constable kind of out there in his car to watch him wherever he went. That was Justice Alito's point. He said, you can't do that. You can't put tiny constables on everybody all the time. We can now. So what used to be a matter of the government agreeing that it could not do certain things using technology, it turns out that that could was a weird word. Did we mean could not because it was not technologically possible? Or did we mean could not because society won't stand for it? And here I'll reference my idea of pragmatism one more time. A rule does not exist if it does not change an actor's behavior. So, if a rule doesn't create a difference between what the government can do technologically and what it does do, then we may say that that area is lawless, that there is no law in that area, because there's no difference between what the government can do and what it does do. Again, what the right answer is, I've got no dog in that fight. But I do worry that unless we re-characterize what we've long thought of as civil rights and civil liberties, and we say, we understand that in the next 10 years it will become possible to do these things, but there will need to be a gap between what we can do and what we do in order for us to be able to detect the existence of law in that area. I think we're going to need to insist on that because some things are going to get very, very, very cheap very fast. I'll give you an example. My uncle, who founded Rosetta Stone, the language learning company, had a saying. He said, you can never be too pretty or have too much hard drive space. And he was right. It turns out that it used to be too expensive to store a lot of what's being stored now. It turns out that it is no longer all that expensive, that we can store the details of transactions long-term at a fraction of the cost each computing cycle generation. Which means we're going to be able to do a lot of things. And I don't just mean the spooky NSA buildings in Bluffdale, Utah, although, I'm talking about the spooky NSA buildings in Bluffdale, Utah, but also for commercial clients, being able to keep records of a person's set of transactions over 20 years. We haven't been able to do that before. All we know right now, look, I mean, my computer is currently very, very confused. I have 4 daughters and 1 exchange student, which means that my Netflix account thinks that I'm very much into My Little Pony. So right now, these big data algorithms are kind of confused. Wait till they get 20 years of data on us. Then we're going to have to decide what is the legal basis. How do we even think about contracting? As an economic deal between 2 parties who are equally in positions of equal information? No. Trying to cut a deal with somebody who's got 20 years of your economic data is kind of like trying to win at poker with somebody who can see your cards, right? Nobody's doing anything dishonest. Nobody's doing anything malicious. It's just that one party is going to know so much more about the other party that I just wonder whether we're going to rethink what it means to enter into even a basic online contract. Okay, so I'm done. I'm going to sum up. Laws do not get left behind by technology. Laws are there before technology is born. Lawyers reason by analogy, by flexible, robust analogy, using stories, because that is a great way to stay ahead of narrow technological change. We just say, it's the same story as last time. And I'll end with this. A court in California just decided that Bitcoin was, for the purpose of the bankrupt estate, property. Big surprise. Law was there first. Thank you very much.
Wait for the mic before you ask your question. If you have a question, you just raise your hand.
Have you thought at all or studied sort of the evolution or really the changes in patent law over the last 10 years or so? And I'm wondering how that fits in with your paradigm, both the rewriting of the patent code, I guess it was 5 or 6 years ago, and then there have been more recent attempts to go back and rewrite it again, correct it, and I know there have been a number of major sort of cases decided, some of which, as I understand it, mooted out some of the bigger issues that people were wringing their hands over when the patent code was first rewritten, whenever it was 2010. But how does that fit with your paradigm?
That's a perfect question, because it's the kind of one, it's the one that I ought to have thought about but haven't yet, and therefore my off-the-cuff answer will hopefully be interesting. What I think we've seen in the patent area is a mixture of these two narratives of law. On the one hand, certain statutory elements of the patent code were badly out of date, and moving to first to file was a good idea, as opposed to first to invent. First to invent was too hard to prove and created proof problems, and so we just said, we'll move to first to file. But I think the biggest changes have been away from the statutory language, and they fit perfectly, I think, off the cuff, with this theory. So if you think about the big changes, no one ever thought that subject matter patentability would be a serious question. If you'd have asked people in 2007, they would have just said this is a dead issue. Friends who taught it never thought that whether the subject matter was patentable would come up. And instead, the court has gone back to these kinds of old, flexible analysis. I mean, they even trotted out rule of nature, right? In some cases. They said, look, it's a mathematical rule, an algorithmic rule, a rule of nature. And so some people scoffed at that and said, right, that's ancient. And that's outdated. And I guess the only insight I might give there is, yeah, maybe. But it's also grasping at a set of intuitions that people had very early on about what you should be able to claim as intellectual property. And I've taught my students, why in the world isn't an algorithm, or why in the world isn't a mathematical equation patentable? These things are invented. They take enormous creativity. The answer seems to be because they're necessary building blocks to create other technologies. I think that story is being expressed by the court when it uses old language like you can't patent a pure algorithm or you can't patent a law of nature, in the same way that the bankruptcy court said, looks like property to me. Again, using the oldest rules to solve the newest cases. But that's off the cuff, and I'd love to hear more from you on that. There's one in the back.
So you talked a lot about the relationship between people and the government, but what about interactions between people and corporations? Recently, we saw the case with net neutrality. what is the government's role in adjudicating, whether or not internet is a necessary good that people should be able to trade, whether or not the government has any role, and whether or not these companies should have the freedom to contract with individuals. And I'm just interested in what you think about that.
Yeah, great question. I've tried to make it an art to answer things as cleanly as possible using the fewest possible words. So we'll see if I can do this. I think that one, this can be a great example of using the oldest rules to solve the newest cases. There's a reason why the FTC has stepped up as the regulator. And that is that it's got the old language in Section 5, which says that it gets to bar unfair or deceptive acts in commerce. Now, to anyone who's a lawyer trying to help their client mitigate risk, those words ought to make you break out in hives. But because they have that breadth of language, they've been able to step into the position of, broadly speaking, internet regulators. Now, the FCC has now come in and kind of taken their lunch after reclassification, which was the net neutrality point that you've raised. They show every indication of following the same result. And again, although it is weird, and I commend to anybody who's interested in reading it, Daniel Solov and Woody Hartzog's article on the common law of the FTC's jurisprudence. I cannot describe to you how weird this situation is, all right? For any trained lawyer, this is weird. But what is going on right now is that privacy lawyers especially, and other folks who are dealing with electronic commerce are reading the settlements of the FTC with the companies as if they were case law, as if they set precedent. They don't. They're not. But it's created a body of what? Of law that has no claim on the subject. Look, I can't make this up. If you go and read Chris J. Hoofnagel's book on the FTC, it's all about this, and yet there's no law there. They're whole law books with no law. Why? I argue it is because the FTC has taken this method because it is the only way we deal with technology. We take the old words, we fit them to new situations, we do it repeatedly, adaptively, and iteratively. And that's exactly what the FTC is doing. Exactly what the FTC is doing. It started by saying, okay, it's deceptive if you say you're going to do something online and you don't. You lied to your customer. Then they moved to, it's unfair if you don't use the latest encryption practices, which is a little more of a stretch, right? So they built this up repeatedly, iteratively, one step at a time, looking exactly like the common law process, except that these are not common law decisions. What this shows to me is the need for that kind of process, even where no legal system in our country validates what the FTC has been doing. There's no reason to treat those settlement agreements as precedent. None. And yet we do because we've recognized that this is a pretty reasonable way of creating rules. So that's took a little longer than I'd liked, but that's the cleanest answer I can give you. That's great.
Yeah, you had mentioned that, at least historically, there was a sense that the government would agree that there were things that it could not do. Now in the case of cryptography, which is basically math, I mean, they might be lucky enough to attack a particular implementation of that, but strong cryptography is there, available, and anybody can have it. So the reaction that we see from government is an attempt to say, no, you're not allowed to use it.
Right.
Does that fit?
And that fits, right. So I should say what's good for the goose is good for the gander, right? That is, we often have claims on the government saying there ought to be a difference defined by law between what you, government, can do technologically and what you are permitted to do legally, right? We need to see that gap there for us to trust you. They also, by the way, get to say, yeah, and by the way, the law needs to create a difference between you, Josh Fairfield, between what you are capable of doing and what you get to do legally, right? So, I can do all kinds of dumb stuff. Pretty much with an internet connection, I can do dumb stuff 30 times a second. I don't because there's that gap created by law. So you're absolutely right. Now, the question of cryptography in particular has become a bit of a flashpoint because I think the government is convinced for the first time that the citizen can back up their threat of doing something that the government cannot respond to. That's a bit new to the conversation, right? There's always been a gap created by law. I've always been told, look, you can shoplift, you may not shoplift, right? That gap's always been there, but there's never been a technology that I can think of that so fundamentally says, oh yeah, and by the way, if I choose to act within my technological capability, there's nothing you government can do about it. Now, as a pragmatic question, of course, the idea that we can't crack cryptography is not true. We can't get through the cryptography, but nobody needs to. You go around it. And you social engineer the device, and that's what the FBI did, and that's why the FBI withdrew its case, is because there are 1,000,001 ways to get into these things, and the cryptography is great, but it doesn't stop government penetration. But your point remains a fantastic one if we were actually able to get cryptography to be end-to-end locked down. At that point, that would be one of the, I mean, can you think of any other example in history where the citizen can really make good on their threat, saying, look, there's nothing you can do about this?
Well, there was a FBI case over full disk encryption.
Yeah. Yeah, the Colombian guy, right? And he was using TrueCrypt. Yeah, and they were just running hashes against it for a year. Right, so again, that's encryption, right? So I'm just trying to think of any other technology that does that, that really sort of lets the citizen act unilaterally. The government can act unilaterally a lot of the time, but it's very rare for citizens to be able to just go, well, nothing you can do to stop me. That one's rough. So I agree that one's occupied a unique place in our thinking. That's a great question. More.